Welcome to the Information Ecology lecture series for fall of 2007. This is a lecture series put on by the Center of the Study of the Public Domain. It is organized brilliantly by Jennifer Jenkins, who's sitting in the front row, who's the director of the center, and who teaches several great classes with us, one of them with me, I'm glad to say. The Information Ecology lecture series brings together people who are thinking about law and about policy and about economics and about psychology surrounding the dissemination, creation of information, information goods, creativity, and so forth. It's deliberately a broad ambit. Our speaker today is Professor Mike Carroll, who teaches at Villanova Law School, and we're really delighted to have him here. I'm particularly delighted. Mike is an old friend, and actually in preparing for this introduction, I was quite horrified by just how much work we had done together, since it seemed to indicate that we were old. But I rejected that. I rejected that unworthy conclusion and moved on. I first met Mike when he was the lawyer who effectively did a vast amount of the work in setting up Creative Commons, which is an organization on whose board both of us now serve. And while there were many amazing people involved in creating that, and certainly Larry Lessig and Hal Abelson and others deserve the lion's share in terms of the inspiration, it was quite clear to me early on that Mike was one of the reasons why the organization, and in particular its licenses, actually functioned. And I realized at that point that he had a quality of good judgment, which is often, sadly, lacking in lawyers, and even more often lacking in academic intellectual property lawyers, perhaps not quite as necessary for the academics. I then got to know Mike as I continued to work with him, also as a colleague as he moved into academia, and he's really done some fabulous and interesting work, which I'd strongly recommend you look at, either at his SSRN page or at his homepage at Villanova. Among other things, the talk that he's going to give today will draw on a series of articles that he's done on the history of music copyright, which really brings out the fabulous and illustrative history of the way that copyright law tried to confront this mysterious subject matter and make it its own. Mike's also written a couple of really interesting articles on the problem of uniformity cost in intellectual property law. Uniformity cost is the problem that intellectual property law has only a certain number of Procrustean beds into which it forces all technological and cultural innovations. And while that has advantages, lots of different types of innovation get covered by patents, lots of different kind of expressive creations get covered by copyright, it also has costs, and the article, Mike's article, suggests some general frameworks for thinking about how to think about those, the trade-offs between uniformity and the costs that it imposes on us. Mike has also worked with me in particular in setting up two organizations, CC Learn, which is an educational division of Creative Commons, and Science Commons, and he is the eminence pas grisée who has really been the leading, one of the leading figures in the open access scholarship movement, particularly on the legal side. The open access scholarship movement is the movement to have an increasing proportion of scholarly publications available under licenses which permit, at the very least, its free downloading and reprinting from the World Wide Web, and perhaps more. And Mike has written a number of the author addenda, which take the radical step of actually allowing authors to archive their own works on the internet, even after they have published them. So anyway, we're delighted to have Mike here, and I'm sure that his talk, which is on copyrights, music copyrights, federated domain, is going to be a fascinating one. Thanks very much.
Jamie, thank you. Are we on? Good. Jennifer, thank you for organizing this. So, hi, and I'm sure that you're all here to talk about music copyright, and the free lunch has nothing to do with your presence in this room, right? Okay, so I'm going to talk, today's talk is a bit of a synthesis of the two projects that Professor Boyle mentioned. I want to talk about the history of music copyright, but I want to put it within a conceptual framework that deals with what I've called in economic terms the problem of one-size-fits-all or uniformity cost. Right? Copyright now applies to any original work of authorship. And so you can find an original work of authorship in a parts catalog, in a shampoo label, right? By driving the concept of copyright up to that level of abstraction, the domain of copyright now expands to include a wide variety of works far outside its historical ambit of maps, charts, and books, right? And I want to get a little normative today about that. And instead of just using law and economics jargon and talking about uniformity costs and things, I want to rail against copyright's empire. Right, that the concept, and I actually, it's a broader jurisprudential argument. I want to argue against certain kinds of imperial legal concepts that we've mapped onto the world. And I want to use our own American democratic tradition to think in terms of federalism and federated concepts rather than imperial concepts. So I want to make an argument here that we ought to be thinking of the concept of copyright as a federated concept that has certain constitutional principles that unite it, but then leaves room for local variation in the various artistic and creative communities that are regulated by copyright. And I want to argue that that's actually the law we already have, and we just have failed to think of it in those terms. So let me put a little meat on that. The original work of authorship concept, all right, it applies automatically without any application or registration. So the federal law right now regulates any creations that occur without any preconditions. And with the explosion of digital technologies, the domain of copyright law has expanded correspondingly. So what I call every time that you make, under copyright law, we do prima facie infringement, and then we do our exceptions and defenses later. So prima facie, we constantly are infringers of copyright because we constantly make copies of works, we distribute copies of works, we publicly perform. Every time you surf the web, you're doing that, right? So copyright's domain has expanded without question because we don't ask what kind of work is this. As long as it's an original work of authorship, you're inside copyright's domain. And even the concept of copyright is now being treated as a species of intellectual property, so that there are forces in the world trying to drive the concept even higher. And in fact, when you recently, in relation to some recent legislative action, some intellectual property owners have been arguing against discrimination, that somehow or another intellectual property is not sufficiently protected as is real property. And I want to suggest that this has imperial characteristics. If you drive the concept that high, and then you say, our basic concepts that apply to property apply anytime copyright applies, someone who says, but I'm different. That's not how it works down here in the music community. That's not how it works down here in the visual arts. You don't get to argue that against an imperial legal concept, because we say, well, we've decided that this is property and these are the rules that apply to property. So in that way, copyright has certain imperial features, and that's problematic, in part because if you care about what's actually happening on the ground when copyright touches down, there are a lot of differences in the way that creative communities operate. And those differences, I argue, from an economic standpoint, ought to be accounted for, and also from a sort of sociocultural perspective, ought to be accounted for. And so if we start thinking about copyright's federated domain, we make space for that kind of localism, if you will. And if you look at copyright as it is right now, and let me just ask, how many people have had a class in copyright law? All right, only a few. Okay. Well, the Copyright Act is structured so that it starts out really simple, right? Anything that's an original work of authorship is subject to copyright, Section 102. Section 106, here's the list of exclusive rights, right? Reproduce, distribute, prepare derivative works, perform, display, right? That's the list. So far, so good. Then you hit Section 107, and from Section 107 to Section 122, you hit the tax code. You get a series of highly specific sort of variations, exceptions, limitations that generally don't get taught in the normal copyright class. And so we just sort of wave our hand because in copyright's imperial domain, Those are just minor variations that we don't have to worry about. But within a federated concept of copyright, those provisions are important. Those are provisions where individual creative communities or businesses that operate in certain creative domains have said, we need to tailor the basic rules. They don't work for us. And we need highly specific, almost contractual arrangements to deal with our reality. So I suggest that that is the law we have right now. And if you look at those sections, guess what subject matter gets the most complex and highly varied terms? It's music, right? So for example, any of you guys are in a cover band, you want to put out a CD, you don't have to ask the composer for permission before you want to record your record. Right? Sid Vicious wants to record Neil Sedaka's I Did It My Way. He doesn't have to ask Neil for permission because there's a special license in the Copyright Act that says as long as you pay the fee, you have a right to make a cover version. Right? I want to stage a version of one of Martha Graham's dances. I can't. I don't have that automatic right. So we treat musical performers and their right to record underlying compositions differently than dramatic performers, dancers. Why? We don't have a theory that explains that. There's a historical explanation, but I want to suggest that there's theoretical justification for treating music differently. And within a federated concept of music copyright, we're allowed to explore that. There's another reason I want to argue for this sort of federated concept of copyright, is that if you want to ask the question, does the First Amendment ever limit the scope of copyright, place an independent defense or barrier to the expansion of copyright, the Supreme Court has said, generally the answer is no, unless copyright spills over the bounds of its traditional contours. So this has put copyright history into play, right? Now we have to understand what copyright's traditional contours are to understand when free speech values may place an independent limit on copyright. And within this federated concept, I want to argue that we can pay more attention to the traditional contours from the ground up. So if we look at copyright from the ground up, which is what I want to start doing now, and look at it from the perspective of musicians, music creators, people who care about music, and we treat copyright now as functioning as basically creating a kind of music policy as opposed to arts policy or cultural policy. Let's be a little more specific and say, in what way has copyright functioned as music policy? It gives us the room to care about what's special and different about musicians while pledging allegiance to the constitutional principles that we want to create a set of authors' rights and that there ought to be a distinction between ideas and expressions. So at those high levels, those are constitutional principles that unite the concept of copyright in all of its different domains. But as we get down and we ask, well, what should the scope of copyright be? What has the scope of copyright been? Let's not assume the imperial stance, but instead ask from the ground up, from the perspective of musicians, from the perspective of the music business, what are the traditional contours of copyright? So the research I've done, initially I assumed, well, the music publishing business started during the Renaissance, so we'll sort of pick up the story there and move forward. And as I started to think about it more, I realized that was kind of an arbitrary distinction, and I would drive the research further back. I stayed within the Western musical canon just because that is the sort of reference point for music copyright, since copyright is itself a Western invention. And I did this in part, and I focus on music because it is the most sort of tailored part of copyright, but also because there's another story about copyright law that I think focusing on music takes us away from. There's this version that, well, you know, it made sense that copyright started with maps, charts, and books because those were the things that got printed. And the story here is that copyright just expands to catch up with technology. So every time there's a new technology, copyright's domain expands. Photography comes along, now we're going to deal with photography. Movies come along, now we'll deal with movies. So this suggests that there always was an imperial concept, and its domain just expanded as technology expanded the form of expression. Well, you can't tell that story about music. We've been making music for as long as we've had language of any kind, perhaps even before. And we've been printing music and writing music for quite some time without copyright applying to it. So it can't just be that technology expands the domain of copyright. Instead, the concept of copyright has been mapped onto creative communities that had pre-existing relationships and understandings about what they were doing. So the first thing I wanted to ask is, well, prior to any legal categories, on the ground, when did musicians first start to relate to the music they created as something that they owned? When was the first claim that said, this is mine? And when did they say, and you can't do X with it? Now, unfortunately, I can't find that magic moment when it occurred, but I can tell you that there was a long period of human history when musicians did not relate to their musical creations in that way. So if we dial all the way back to classical Greece, most of the musicians were slaves, right? And the form of music was something, musicologists are not exactly sure, but it resembled something along the lines of Indian raga, sort of these long improvisations based on a set of sort of accepted themes. And in classical Athens, it was a highly competitive culture. So you had the equivalent of the Battle of the Bands, right? It was a form of athletic competition. And the winners of those competitions had the sort of social status of star athletes today. So the popular music figure is not a new creation at all. But they were popular for their skill in manipulating these traditional forms and performing them, not as composers. In fact, the distinct social category of a musical composer is a relatively recent phenomenon. And if you want copyright to apply to music, you have certain preconditions you need. You need an author, right? And you need a writing. And music had the capacity, we had the capacity to think about musical creativity in those ways as having distinct composers. And we had the capacity to think of writing music down. But neither of those was done. So ancient Greece, musical notation was invented in ancient Greece, but it was rarely used. There was a thriving book trade. It was in handwritten manuscripts, but the book trade starts, 500, 400 BC, and basically continues nonstop. So we have authors and writings in classical Greece, but not with the domain of music. So already there's a distinction about music's role in sort of cultural expression and creativity. I won't tell you the whole story in detail, but as you move forward, the Greek notation system was largely lost, and so during the Middle Ages, there was a reinvention of musical notation. And here its reason was different. As the Catholic Church was trying to form itself into a united church and have a canonical body of sacred music and sacred texts around which it could assert its authority, there was a need to regularize and formalize the performance of sacred music because lots of different religious communities had their own versions of music. And at the time, it was monophonic music, right? So there's only one melody line, right? This is the Gregorian chant is the version you're probably familiar with, but there were multiple different kinds of chants. And of course, the conception of what this music was that this was divinely inspired music. So to the extent that these were not just variations on old themes, but new creations, and there were new creations, the authors or the composers of these new creations understood themselves to be the vessels of some kind of divine inspiration and did not claim an ownership interest in these new compositions and did not relate to, well, you can't do X with it. But we start to see the elements of propertization when the church starts to assert control over melody, control over authoritative text, and then wanting to render that into print. And the fascinating story about how that happens, over a 400-year period of time, the relationship between sort of the printed object and the performer changes. So initially, once the notation system is there, then the understanding of the text is, well, I heard it this way and this is what I wrote down, and then someone else hears it differently and writes it differently. And the understanding is these are sort of notes for performance, but you're free to improvise, free to just use this as a reminder. How did that one go? Oh, yeah, right. Over time, the notion is now the score commands the performance, right? So now it is not an authentic performance until you're abiding by the authority of the score. So the authority is vested in the score. It becomes an authoritative object. And now we have a text on which we might start to map some legal rights. But again, the creators of those texts do not consider it to be their authority that they're asserting. It's God's authority that is attached to the text. And it is not regulated, it's not the copying that's regulated, it's the heretical expression that's being regulated. Dial ahead now to the Renaissance. We get the printing press, right? Now we start to get the elements of something that might resemble copyright, right? Because now we have printing, the publication of these texts. And there is a market for printed music. Because now that the text has gained this authority and people want access to the authoritative text, and now we have a technology that makes that able to distribute that more widely, there's demand. But it's mostly for sacred music. Music printing is hard, right? As compared to movable type and doing books, think about printing music. You need staff lines, right? And then you need to put the notes onto it. So originally, you had to run the paper through 3 times. So it was actually, if you wanted to go in the music printing business in the late 15th century, you had to be a more skilled artisan than you did to be printing Bibles and the like. So it's a limited set, and it's centered in Venice. And I have to tell you, when you read the stories of the way these printers set up shop, acquiring a printing press wasn't that hard, but it really reads like Silicon Valley in the 1990s, right? You got all these people who say, there's this new business model. I'm going to go into music printing. And they got weeded out in much the same way that the companies in Silicon Valley got weeded out. And the competitive, there was competitive hijinks, resemble a lot of the things that we've seen in those high pressure cooker moments of fast development. So music printing starts to take off. And one of the tools in that highly competitive environment is legal regulation. So Venetian printers initially and other printers would go to their local political authority and say, I'm about to spend a lot of time and effort to print this music that's probably got a limited set of demand, and I need protection, right? So we didn't have copyright available at the time to supply the protection, but we had a printing privilege. This was a right that was granted to the printer, not to the composer. And it said, by undertaking the risk of investing all this time and effort to create this beautiful music that I'm going to distribute to 400 people, or I'm going to create 400 copies, I have the exclusive right for the next 10 years, oftentimes 14 years, to print this style of music. Or sometimes it was this method of printing. So what we now think of as patents and copyrights were not distinct. These printing privileges were ad hoc legal regulation that could apply either to methods of printing or to subject matter. I have the exclusive right to print sacred music. I have the right to print, this kind of chant. You look at them and there's a lot of variation, but this tool starts to spread across Europe as the different courts are all in a competitive race to sort of own Renaissance culture, if you will, be at the forefront of Renaissance culture. So you've got the French court adopting this legal privilege. You've got, it comes a little bit later to England, right? But at this time, still, the musicians are creating this music, and now the form of regulation that the church has said, we need canonical texts, has actually created a problem. It was supposed to control musical expression, but it's a new form of creativity. Now the music becomes visual. And so you can start to create in a new way. And you can say, well, what if I write this other line on top of that? And we see polyphony, having more than one melody line running along, emerge, and the church is trying to suppress it. But you can't put, creative people down. They've got this tool. They've got a new space. Think about the printed page as a creative space, and they can't help it, right? But even as these early Guillaume Dufay and other sort of composers are creating this new form of music, they're still within the model of, I've got patronage to be the head of the chapel, and I'm sort of channeling divine inspiration. So often they wouldn't put their names on the music. Right? It wasn't until sort of later that people would go back and try to figure out who wrote which manuscript. Right? So the authorship, we don't have the composer yet, although we start to have enough competition among the courts, and I don't mean legal courts, I mean royal courts, that you would start to get people who would specialize in the composition of music. Right? So Noble wants to put on a good show, wants to have some new music that no one's ever heard before, commissions a piece. And the most popular composers start to get enough commissions that they start to specialize, and they're not just performers anymore, they're composers. So we start to get the elements of an author that we would need if we wanted to have music copyright. As far as I can tell, the Flemish composer Orlando Lassus, who moves to Italy and changes his name to Orlando di Lasso, is the first composer to get legal rights as a composer. So what happened is he complained. He was the guy, right? He was the guy that all the nobles wanted. The Italian courts were the richest courts. That's why he moves to Italy. He complains that there are these German printers who are printing messy editions. They're getting it all wrong, right? Because again, we've already established that the text is authoritative. It represents the authoritative command from the composer to the performer about how the music is supposed to sound. So if the printer is making mistakes and being sloppy with it, that chain of command is broken. So Orlando Lassus appeals to the French court and says, in my capacity as composer, I need the privilege to authorize whether someone can print my text or not. And as far as I can tell, that's the first legal rights granted to a composer as author, as opposed to the printer who's taking the risk, the market risk. And I would say that's the seeds of music copyright. But the right is a highly limited right to print the music, right? There's no performance right. And I can take that printed text and I can perform it without asking permission. It's only the right to print the text. All right. So I'd argue that, and this form of ad hoc regulation, this legal printing privilege, of course, applied to books as well. So at this point, music and books are largely swimming in the same pool. And with this emergence of the composer, analogous to the author, we start to have, okay, it's at least, these two ought to be federated, right? They ought to, they belong, they're competing under the same kinds of conditions. And the author, interestingly, it's the publishers who start to create the social concept of the composer. It turns out that people will buy music more readily if they feel like they've got some connection to the person behind the music. So the publishers would start to advertise what a great person this composer was and how this music reflected that great personality. So and then the author said, really, I'm that great. So they started to say, well, isn't that interesting? So the concept of the composer in some way emerges out of the competitive position of the printers. And the printers are largely enjoying, other than Orlando di Lasso, it's largely a printer's right. But they've created the monster that is going to come and get them with copyright, because now there's a social figure, an author, a composer, who can start to claim rights to the text. So I'm going to fast forward a little bit. As we go into the 17th century, England sort of granted these printing privileges on a guild basis. Rather than ad hoc, piece by piece, the stationer's company gets the printing privilege. It's a general grant. Any books that have to be printed have to go through the stationer's company, and there's a licensing regime attached to that as well. Basically, there's a deal with the political authorities. You can have all of the economic rents that come from a monopoly position so long as you also do content control as we direct. And so that's the regime that obtains in England in the 17th century within the company of stationers, right? So they're granted in gross the right to print. As between themselves, who gets the right to print a particular title, they have to work that out. The way they work it out is they create a register, and on that register, individual printers would register their copyright. I have the right to print X title. And it's from there that we get our modern concept. I mean, that's where we get the word, and that's where we get the concept of a registration system and copyright. Music, interestingly, within England, tended not to be within the stationer's company system. The music publishers were still outside that system, operating under royal privileges. Because it was a specialized practice, and they weren't, although they participated with the guilds, they were a distinct enough community that the music sellers were treated legally differently. Within the booksellers, there's a battle over whether copyright is perpetual or not. And at the end of the 17th century, Parliament finally has sort of had enough with these monopolies granted by the Crown, and they do not renew this act that confers the monopoly on the stationer's company. So in England, there's a period of unfettered competition from about 1695 until 1710. So that's an interesting point for folks interested in the economics of intellectual property. What happens when there is none? And, you know, surprise, surprise, lots of people went into the printing business, and they did sort of publish each other's titles. So it's hard to read that evidence. The standard story is if you don't have intellectual property, nobody's going to make the risk of investing in printing. The evidence doesn't bear that out, but it does show also that there was a lot of unauthorized copying, and so who knows how that system would have worked. The publishers were able to cut that experiment short by returning to Parliament saying, look, we really need trade regulation here. We really need some kind of control over our books. Parliament said, we've done enough. You know, you're politically unpopular. And then they discover the author. We don't need a printer's right. We need an author's right. Right? So we get the Statute of Anne, 1710. This is the first Copyright Act, and it's granted to authors. And it's granted in books. Right? So the next part of the story I've investigated is, well, what happened with music copyright? There were music composers. Were they within this regulation or not? Because there were still royal privileges that had been granted to music publishers. And there was uncertainty because is a musical composition a book? Right now we're just doing standard statutory interpretation. What some researchers have done, and this is fascinating, is they've, the courts of the British equity courts, the records of the British equity courts, their researchers have gone in through those dusty files and found the records of early litigation between music publishers and composers, where composers started to make the argument, hey, we're authors and our compositions are protected under this new statutory regime. You can't publish our works without our permission. And the music publishers said, oh no, music is not a book. Are you kidding me? And it turns out that it's Johann Christian Bach, the youngest son of Johann Sebastian Bach, who finally brings the case 60 years later in which this issue is resolved. So it's an equity case, and finally the courts of chancery decide that this really is a question of law, even though they've been deciding it on equitable grounds. So they refer the question to the law courts, and Lord Mansfield, who is one of the early copyright imperialists, says, well, of course it's a book, right? actually doesn't say it's a book. He says it's a writing, and I won't go into it. The operative term in the statute of Anne is books, although it mentions writings. His holding is music is a writing, but he says it's therefore protected by the statute of Anne. So composer's copyright is born in England in 1777. Right. So copyright, the way I want to think of that story and that historical moment is that music joins the Copyright Federation that's being built. Okay. But notice, again, copyright is just a right to print. Mansfield specifically says in his opinion, if you own the copy of music, of course you're allowed to perform it. So something that will be a subsequent battle in the history of copyright about whether composers have the right to control public performance of their work, right? The allocation of that entitlement in 1777 is clear, and it's clear that the public owns the right of performance, and this right of copyright only applies to the copying of texts. So I think the federated concept gives you more flexibility in thinking about how this area of law is developing and how the sort of actions on the ground expand the concept and the actual legal scope of copyright. I've got another piece in draft that's about what happens in the United States. You would think if music copyright had already been established in England in 1777 and the first Copyright Act in the United States is 1790, why wasn't it just automatically encoded? Remember, music copyright was a matter of judicial interpretation in England. It later becomes codified. But the American Act just says maps, charts, and books. Right? So was music copyrightable within the United States? We didn't have to litigate that question because in 1831, musical composition gets added to the Copyright Act. But notice, it wasn't automatic. Somebody thought music was treated separately and needed to join the Federation explicitly. And frustratingly, I'm able to tell you who inserted that amendment, when it happened, its provenance, but I can't tell you why it happened. Right? So the focus of that piece is, was this a standard public choice story where some music publisher said, we need legal protection to add us to copyright's domain? And the evidence I've been able to find suggests that that's not the story. Instead, the author of this amendment was a New York congressman running with James Fenimore Cooper and others in the literary circles of New York. And in his mind, this concept of copyright needed to be expanded to include musicians. So it was the imperial copyright finding a voice. And there are other aspects of the debate over the 1831 Act that sort of bear that out as he makes arguments about whether copyright should be thought of as a limited trade monopoly or whether it is property owned by the creator at the moment of creation. And what I plan to do with this project, and I want to open it up for questions and comments in a minute, is to continue to trace this story. I've already downloaded all of the music copyright cases and am working my way through and finding the ways in which the courts make special accommodations of the general concepts associated with copyright to music and the extent to which it's just one size does really fit all. Already, I've found that the first cases involving music copyright are not your standard pirate story. You don't have the pirate publisher making copies. Those cases don't get litigated to judgment. Early on, it's always about, well, he stole my melody. And yeah, it's not quite my melody, but it's close enough. And at the time, the concept of derivative works and what we now say sort of whether somebody else's work is substantially similar had not been established. And so my working hypothesis is actually that the music cases helped drive expand the concept of copyright into this domain of similar and derivative works. And then it fed back into applying to literary compositions and other forms of expression. If we had a more federated concept at the time, you might be able to argue that the scope of copyright in a musical composition may need to be different than it is in a literary composition, in part because of the differences in the way you use pre-existing works in those two creative communities and the creative practices that drive music forward, and what kind of incentives do we need to deal with those problems as opposed to literary composers and book publishers. To me, seemed like those differences may have been material had that been on the table, had there been a conceptual framework in which you could say, let's operationalize these differences while understanding that the underlying problem is that creators need some form of economic protection in order to have a sufficient incentive, or at least the publishers do. And I want to then finish telling that story to start where, to end where I started this talk. When you read the Copyright Act today, there are all of these highly tailored provisions that deal with music, and this concept of federated copyright helps you explain why that is. And when we think about what good copyright policy as it applies to music ought to be, right, let's look from the ground up. Let's look at the musical creative practices that are happening today and look at the way in which copyright interacts with that. Right? One example that ought to be familiar to at least some folks in the audience is the practice of music sampling and the genre of hip hop. And it's fairly well established that prior to the 1990s, when the copyright cases started to get litigated, hip hop artists were quite free with their sampling, and you could find multiple samples in a single track. Right? After 1990, you start getting these cases, and you get an early case in which a district judge pronounced that this was theft, because of course within the imperial domain of property, any taking must be theft. And the record companies get a little gun shy. They start requiring licenses among each other for their artists. And instead of getting lots of small samples mixed and mashed in interesting ways, we get a couple of licensed samples, and if you're going to get a license, you might as well loop the heck out of it, right? And so we get the same bass line runs through the whole piece rather than having multiple shifting bass lines. So the legal regulation of music has an impact on the music that we get to hear, right? But of course, we don't think from the ground up, so we don't ask the question, is that right? Was there something about pre-1990s hip hop that we've given up that we shouldn't have given up? Isn't there a way to keep the freedom that those composers and turntablists had while creating a sufficient compensation mechanism for musical artists? But we don't ask the question that way if in a domain of imperial copyright. We just ask, was there an author? If there was there copying? If that's the end of the story. And so I'm trying to argue that's not a good way to do music policy. It's not a good way to do movie policy, book policy, right? Let's look at the different practices and understandings of these creative communities. Let's look at the underlying economic structures in these communities and figure out what role copyright ought to play in creating some kind of economic reward while leaving enough freedom for new creators to build on the old. And with that, I thank you very much, and I'd love to hear what's on your mind.
Hi, Mike. So all the stuff that people don't teach in the copyright course because it's too complicated, these are all, and I'm sure, I don't know if Jerry's here, these are all liability rules of various sorts that are set up in music. So in some sense, it isn't as, as you pointed out, it's not imperial in the way other pieces of intellectual property are imperial because there are all these liability rules. And yet I think you're saying that, is the rate set too high? Is that the problem? Is that why we don't see more interesting hip hop? Because you said that if you have to pay for it, you then loop the hell out of it. But presumably that just means the rate's set too high, right? Or
well,
what is the? It does seem that, at least in music, it's not as imperial as, for example, other areas of intellectual property.
Right. Well, although, the recent cases, because they're captured by an imperial concept, don't actually pay attention to those tailored provisions. So this Bridgeport case, which says if you want a sample, get a license, comes to that conclusion by misreading the tailored provisions of the Act. But I also want to push back against the premise. It's not just that the tailored provisions deal with statutory licenses. The scope of a copyright in a sound recording is different than the scope of a, right? You don't get substantial similarity protection for sound recordings. It's only exact duplication, right? And if someone independently copies the performance and mimics it, there's no liability. So again, there's a decision there that whatever authorship goes into the recorded version of a song gets treated differently than the authorship related to the underlying musical composition. So some of the problems are, yeah, that we just aren't clearing the market because the price is wrong. But in the case of music sampling, there's not a statutory license. We've decided that one size fits all, this is a work of authorship, and if you want to copy, you need permission from the copyright owner. And the negotiations over licensing samples are notoriously arbitrary, right? And there's a lot of bargaining breakdown, and I know some economists will tell you that bargaining breakdown is not evidence of a market failure, but I would argue in this particular case, there are a lot of samples that ought to get cleared, but they don't for traditional market failure reasons. All right.
Thanks, Mike. Thanks for coming here. I wanted also to welcome two guests. We have Virginia Rutledge, the General Counsel of Creative Commons. Welcome, Virginia. And Leonardo Severa from the European Commission, who's joining us. Leonardo, raise your hand so they all know who you are. So, unfortunately, Virginia's only here for the day, but Leo is around for the rest of the semester. So those of you who really want to go to the European Union really need to go and grab him involved. But he can tell you all about the IP policy in the Commission and how fabulous. That would be it. So my question for you is, one of the greatest protection in conventional copyright for the public domain is not fair use. It is the idea expression and fact expression dichotomy. You publish a book, all the ideas in it, all the facts in it go immediately into the public domain. To some extent, that is the great engine of copyright, pumping stuff into the public domain. You don't have to wait for life like that. So one problem, obviously, in music is it's not clear what the idea of a composition is, and it's not clear what the facts in a composition are. In fact, it appears that a composition is nothing but expression. So there's no idea, and there's no facts. At least that's the way that the courts have looked at it. Do you agree that that's one of the reasons why coverage in this particular part of copyright empire has been so expansive? Or are there other problems? And if you do agree, how could we change the way we think about what the scope of music copyright is so that there was the similar kind of simultaneous private property creating and public domain enhancing function of copyright, which in the music context appears almost entirely absent?
Okay, well, I'm going to disagree a little with the premise, right? I do think the idea expression, so just a lot of people haven't taken copyright yet, but as Professor Boyle suggested, right, the law decides that when you write a book, so Harry Potter, right, Harry Potter has some elements that we're going to categorize as idea and some elements that we're going to categorize as expression, right? So a novel about a young wizard who comes of age and has to fight a dark wizard, right, probably fits into the realm of ideas. If you or I want to go out and write that book, J.K. Rowling has no claim against us because even if we were inspired by reading Harry Potter. But if we start to create characters that look a lot like Snape and Dumbledore and the like, then we've moved into the realm of expression, and she does have a claim because the copyright owner gets to control direct copies and any works that are substantially similar, and in the domain of literary works, substantial similarity is defined quite broadly. So one thing I'd push back against is even within the domain of expression, substantial similarity in music has some limiting principles because there are underlying genres and sort of common forms of expression that get taken out of the analysis. So if there are any musicians in the house, you know, the blues progression is 1-4-5. Most blues songs use some version of that. If you or I want to write a new blues song, we're allowed to use that genre or that idea or that even if it's not an idea, it's expression, but it's so common that it's excluded from the scope of copyright. So there are actually some limiting principles that apply in music that don't apply as readily in literary works. And then structural ideas in music. So the sonata form right, is a ABA sort of form, is a form that you or I can use. That's a musical idea. But I will agree that there's a problem. But to me, I think part of the problem is, what is the musical work? What's happened is there have been some cases where you or I might experience the 3-minute composition or the 20-minute composition as the work that copyright attaches to. So what happens when somebody comes along and copies a 4 or 5 note sequence from that work? Have they created a substantially similar work? And the copyright owner argues, well, but that little sequence itself is a work of authorship, and therefore they've taken the whole work. And the courts have accepted that theory, right? So in a case where the Beastie Boys borrow a 3-note sequence, right, from a flautist named James Newton, the court suggests that we ought to limit our analysis to that scope. That, I think, is a problem. That expands the domain of music copyright, when you get to disassemble the musical work as it was created into all these little pieces and say, I own this piece and the zone of substantial similarity all around each little individual piece. So I think that's a problem. The counter argument is, well, what about ringtones? Right now, ringtones are those little segments, but what if somebody decided to be, my new art form is the ringtone? I am now going to compose ringtones. Are you telling me that I can't own the ringtone as a work of authorship? There's clearly a market for it, and that's what brought me into the marketplace in the first place, and I'm going to be a really creative ringtone creator. And so I haven't gotten there yet. I don't know what the answer is, but this is the type of problem that I want to wrestle through, and the way I want to wrestle through it is from the ground up, focusing on musical creators, what their incentives are, and what kind of protection they need.
Earlier you were speaking about, I think it was a brief period of time in like the late Baroque era in England when there was no regulation, kind of everybody was going into the music business and printing and stuff, and you sort of spoke about that favorably, sort of showing that you don't really need copyright to incentivize that kind of production. But wasn't that one of the biggest problems with that era, is that people were kind of reproducing works with not a lot of care and introducing a lot of errors in, and now people, like the whole point, like musicians now try their best to avoid using the wrong additions from that whole period because they're not authoritative. Right,
so that's interesting. Although so one caution, music was actually not part of that. The music printing privileges still were in force. But also on the printer's error point, that's what you might think, right? If you had monopoly privilege over a text, wouldn't you want to produce quality texts to get people who cared about quality? But a personage no less than John Locke writes a letter to Parliament saying, you've got to get rid of this monopoly because all of the editions of Plato are wrong. And I can't print a corrected version because they own the exclusive right to print Plato. So he's actually complaining that the monopolist, in the absence of competition, has no incentive to get it right. So, and I speak favorably only in the sense that there was a lot of entry into the printing market. I don't know what the long-term dynamic equilibrium would have been, and that experiment got cut off because copyright was invented. Stuart.
Let me push back on the bottom-up. I like bottom-up ideas in general, but I'm wary here because it seems to me there is no neutral position. So we could imagine a world in which there wasn't robust copyright, or maybe any copyright in books, and so then our notion of who Harry Potter was might be very different, because J.K. Rowling writes the first few editions, and then other people start mashing up, and who knows, and now we've got 47 different vibes. It's like China, but it's gone wild. And we would say, well, the bottom-up now world is that people just contribute. It's a world of fiction mashups. And that's what we have that we see in a bottom-up. That's the natural state of writing, as it turns out. Right? We might say the same thing if we had a world with music in which there were no rights, in which people could sample freely. Again, we'd say, well, that's the natural world. To which the response would be, well, that's the world we've created by a certain legal regime here, not having any protection. And so really, I think, fundamentally, I don't know that the bottom-up is doing the work as much as it is that you might have a certain set of normative preferences. I prefer one world that's going to exist in a regime from the bottom up than another. And I know you resist that, but I want to try to understand, what is the neutral position that allows us to really evaluate bottom up in some objective way?
Yeah, so there isn't one, right? It's arguments, not answers, but I want to change the field of argument. So let's take your example of fiction. I don't want to privilege the status quo, but I want the argument to be about what kind of literature do we want, right? What are the conditions under which we want literature produced? And we can have an argument, as with hip hop, what kind of hip hop do we want? We have two experiences of hip hop culture, and now we can have an argument about which is better. But let's think about it in those terms. If we push the argument up higher to one size fits all, right, then by default we end up regulating and deciding what kind of hip hop culture we want, just by making the decision at a higher level of abstraction without thinking about the effects in particular domains. And often what happens then is industries with particular political clout fashion the law in their own image, but because it's one size fits all, software gets swept in, right? So the Berne Convention says you have to treat software like a literary work. So whatever decision under the current regime, whatever decision we make about good copyright policy as driven by the movie and fiction industries applies by automatically, imperially, to software. And I would argue I'd much rather see folks in the software business arguing about what good software policy is and not be coupled with the movie and the literature business, except at that constitutional level. And when you have a federation, you can have a tighter or looser federation. So we might have an argument about how tightly federated copyright might be. But at least within the federated concept, we make room for saying software gets to say we're different, our conditions of production are different, and have arguments within that domain that differ from the arguments within the domain of movies and books.
Really, but that I totally persuaded that we should have the federation. I'm still not sure that the federation is a rising bottom up. It seems to me that if the federation exists, we might want to say to people, what do we think is the best way to create hip hop or the best way to create software? I'm not sure that that's the same thing as bottom up. We might then be applying our own normative lenses about how we want to filter that and figuring out the answer.
Okay, well, it's more bottom up than an imperial regime in which one size fits all, right? So it's intermediate. I don't want a world of completely separate regimes, right? So this is the music legal regime, which is completely divorced from the movie. That doesn't make sense. The regimes and realms interpenetrate all the time. So maybe we're in the middle, right? I just want an intermediate position. There was a hand up in the back. It's now gone.
I was curious if you've done any research or considered the possibility that we can resolve some of these problems by broadening sort of evidentiary rules as it relates to music copyright, particularly as it pertains to music expert testimony and the musicologist's opportunity to sort of explain genre-specific traditions, particularly in hip-hop or jazz, where borrowing or sampling is so prevalent.
Yes, so it's a great point. And the way I've made it in the economic context is that when we do one size fits all, we could choose between rules and standards, right? By choosing to define the scope of copyright with standards, so the scope is substantially similar, that's an open-ended, context-specific inquiry that allows courts in the course of litigation to put some context in. And so part of this argument is when you get to court and you're asking the question, is this substantially similar? If you have a federated concept of copyright, you might think that I'm going to apply substantial similarity differently in the music context than I might have in the software context. And then I would want that kind of contextual evidence because it would be necessary to a good resolution of this particular question. So I'm on board 100%. Now, I'm not sure we need as many, because the legal test for infringement is the eyes of the ordinary observer. I'm not always sure that the experts in music cases are helping. I think You know, the ordinary observer to me is part of a constitutional principle that might be, in that case, the Federation might be a little out of hand. You know, I would actually like to see the music experts go through a stricter screen before they get to testify.
This was a question earlier about the time period when there was no monopoly on printing presses in England. Have you looked at other historical time periods where, due to judicial decisions or the state of the law, there were other similar periods where there was no copyright protection? For example, I'm thinking maybe when photography came out before the court decisions decided that the photographs were included in copyrightable subject matter. Does there seem to be higher quality when you have these multiple competitors that are each taking each other's work?
Yeah, so I'm really wary about generalizing. I would love to say, well, this is a nice data set from which we can draw those kind of conclusions, but I want to be, I'm not sure that we can do that. The other point in time that I've not fully researched yet is after the Bolshevik Revolution in Russia. So Russia has this sort of a form of copyright that gets abolished along with all other forms of property, and it does have some effect. So Russian composers either emigrate or they smuggle their texts out of Russia and have them published in Europe so that there will be copyright protection on the work. So there's some evidence that at least some of the composers felt the need or desire to have this kind of legal protection. But as to your question, well, and there's some evidence that in the absence of copyright, people didn't want to go into the music composition practice, but here you got to pay attention to what the market was. It was an elite market. You know, obviously folk songs are getting created sort of without any copyright regulation, so we can't talk about folk production. As to sort of serious music or art music production, there's so many other political factors going on or events going on that I couldn't generalize and say, here's an economic rule that, you know, we don't need copyright because competition will supply sufficient incentive. The only other point is right after the French Revolution, right, there's a short period of time when the printing privileges are all abandoned, but the Musical Academy is ordered to produce, I can't remember, I think it was three symphonies a year, right? So, you know, we do have some experience with truly imperial cultural production models, but again, I'm very wary about trying to generalize and create conclusions that I think we can apply helpfully today from that. But I am looking, it's the right question, and I'll see, you know.
Thank you very much.